Counselor, if one of those other people, one of the children, one of the wife came to you, said, I want this will broken, you have a case?
Well, I'd certainly do an investigation. But I go back to what Glenn says. You know, it really in this area is all about planning and expectation. And I guess I draw upon, although I'm a litigator, I'm also a mediator, and I try to look at the problem from an overall perspective instead of looking at the singular issue before me.
What I mean by that is, I'm asking here as the non-bar taking member of this audience, how much discretion does that old guy have to just say, my nephew gets everything, everybody else gets nothing? Because
he's got a lot of discretion if he's a good planner. Now, the problem is, and we have a room full of lawyers, is lawyers have a tendency, using our words, and when we do a lot of this planning, a lot of lawyers, and I've seen from, not disparaging the large firms, but I draw a will that's 3 pages. I saw a will the other day that was drawn for somebody who, you know, probably has an estate of $200,000 that was 40 pages. And any time that you multiply the words, that's grist for a lawsuit. And I find that whether it's a contract or a will or a trust, we see that a lot.
Rabbi, there's a particular issue that I'm interested in because I am the firstborn son. My mom would have named My mom would have named me Prince if it was kind of okay. But you want to get it. For instance, is the law, as you understand it, still okay with certain cultures, not just the Jewish culture, but many others, saying the firstborn son, he gets the lion's share? Is there anything other siblings can do about that kind of inheritance? Does it run against public policy in this day and age? Is it discriminatory? Or is it just a matter of the discretion of the person leaving the money?
Now, the wills in Jewish law act a little different. The way it works in Jewish law is when a person passes away, automatically the estate passes as is prescribed by the law. However, there's nothing holding back a person from giving out gifts during their lifetime. So therefore, the major difference between a Jewish, what we call a halachic will, and a secular will is when it operates. Does it operate at the point of death or shortly there before? But there's nothing really wrong, assuming it's properly drafted, in dividing the estate as you wish. Whether this idea that the biblical division might not be practical really goes back hundreds of years. And therefore, this tradition of writing up a will in such a way also goes back that long, and it's not seen as a public policy issue.
Jeff, you know, we find that what's happening, it's interesting you talk about this Jewish will and giving away. We're seeing a lot more cases now where families, while the parents are still alive, the kids are fighting over the spoils before anybody's died. And recently we just had a case where the people fought for years and years and years over the parents' money, and only when the mother finally died, 2 weeks later, the whole matter settled among the 3 brothers that had been fighting all this time. But there's a lot more, I've seen a lot more, both in mediation and in litigation, of this, let's have the fight ahead of time, especially if the parents are, you know, somewhat weakened medical condition or something.
Well,
I'm trying to get my head around this, frankly, because you've thrown me a real curveball. Under those circumstances, why don't the parents do what that guy did in the film? You're telling me that while these parents are alive, the kids are openly fighting about who gets what when the parents die?
Well, and sometimes what happens is the parents aren't on the same wavelength, and one parent, the matriarch or the patriarch, takes control and favors one side or one set, 2 out of 3 or something like that, and you know, the fight erupts. Or it may be the one I did where they were fighting over about $100 million. The one son was the successful son running the business. The father was alive, but that was about it. And he manipulated the father to favor him and supported him in the litigation, seeking peace in the family. And eventually the peace was they came to a resolution.
Okay. I'm just thinking, if I'm the parents, every time I go to my kid's house, I'm bringing a food taster. 'Cause this is unsettling here. Judge, help me out here. If I'm trying to, again, get my head around the idea of a piece of litigation coming before a judge in which and maybe I'm just naive here, that the adult children are fighting over the disposition of an estate when the people with the estate are still alive.
Well, that, of course, was the real estate example that I gave you earlier in the day. That was exactly what was going on there. But what this seems to cry out for, in my very uninformed view, because I don't practice in this field and never did, is the establishment when times are good, when relationships are good, and presumably there will be some of those times, of setting up trust systems and things of that kind, so that while there may be some ability for dead hand control, there may be some ability for disposition one way or another in the course of the wills, there nevertheless are living trusts that have already been set up that will provide for all members of the family to some extent. Secondly, I don't know what the situation is in New Jersey anymore, but I'm not sure you can completely disinherit a surviving spouse.
You cannot.
Isn't there? I didn't think so.
You
So
cannot.
you've still got
Statutory
about
policy.
a one-third dower interest or something? Is that what they still call it,
Yeah,
or is it
there's the,
something else?
the
And furthermore, of
spousal share.
course, if you own real estate as tenants by the entireties, husbands and wives, then that passes outside the will, and she gets it in this example. So, as with most things, that's a little bit overly simplistic.
Well, it's a TV commercial. You know. Now, the mayor's nest that we could probably spend, an awful lot of time on comes when, let's take the example out of these. I'm really getting the case about these kids, by the way. But let's put that aside, and let's talk about parents who are looking at their descendants with the following kinds of issues. Well, the daughter is highly successful. She's making a lot of money. She's not going to need our help. The son is a poet. He's a good guy. He's very smart. He teaches at a school. He doesn't make much money. He's going to need a lot more help. The third one, we don't talk about him too much. But we know he's going to need a lot of help because he's incapable of supporting himself. Where do the equities lie in figuring out that kind of disbursement of an estate?
I don't know if there's any rule when it comes to that. I think that 100% it's within the parents' right to decide however they want to decide. Now, there might be logic behind what they're saying. On the other hand, the daughter who's going to end up with a firm handshake at the end of the day because they think she'll be able to make it on her own, obviously might not take that well. For just as a matter of advice, if you would give her the heirlooms, which have great sentimental value, and give the other ones the stock shares, which have less sentimental value but more value, that might somehow work this out to show it's not that we don't love you. It's not, in fact, we love you, we respect you, but we're going to give things that are valuable to us to you, while we're going to give them things more than what they need. I think what we've been raising here, this idea of pre-planning, I think this happens an awful lot. I'm sure anyone who's a trust and estate attorney or a tax attorney could tell you that this is standard in order to avoid taxes, that many people are moving their estates earlier, not for any great psychological reasons, but for reasons that involve Uncle Sam.
I think they're moving to Florida, not earlier.
Okay.
But okay, I understand that the general piece of advice to anyone is, for heaven's sakes, plan, get a will, do that. Okay, so the parents I've just described come to you, Mr. Margulies. They're ready to plan, but they say, well, here are the three kids. Here are their conditions. We want a plan. What do we do?
Well, I think many people, the judge gave a perfect law school exposition of these trusts, and you're going to treat all these kids equally. That's not real life. That's not real life. And one of the problems I see, and I'm sure Glenn is the one that comes up against this even more, is where you have the son who's capable of running the business, the three daughters, one of which is an artiste, and the other two that are married to son-in-laws who are barely capable of functioning, but function in the business, and where the patriarch is unwilling to do the right thing and take hold and sit down with them.
But wait, what's the right thing?
Well, that's your own moral code. I mean, I have a friend who's going to end up with a tremendous estate litigation, set up the trusts, but they all have disparate expectations. And as a lawyer, what I would advise my clients to do is to sit down and confront the situation on a direct basis as to what do you need, what do the others need, and how can we together plan for that so that there's no surprise when you get to the end.
Does this include bringing the prospective heirs in and saying in advance, here's what I'm going to do?
I think communication is something that's really important to do if the parties are willing to do it. Remember, we're lawyers. We're representatives, we're scriveners, and the idea of bringing in the psychological help and all the other help is terrific if you get people to do it. But it's very difficult because people have their minds made up. They're often resistant to confrontation. They're resistant to having direct communication, and it makes it very difficult. And that's why there's so many. One of the reasons there's so many lawsuits, and we have the acrimony.
Okay, now this is the Jewish Law Symposium, so there's a special kind of issue here, although it is not restricted to Jews, but it's a phrase that's become known as the Jewish clause in the subject of litigation. So the mother, she's widowed, she establishes a trust for her daughter. And she says, this is a revocable trust. And if you marry outside the faith, the trust is revoked. Now, a court in Nevada upheld that. I guess it was Nevada. It's in the materials you have. Illinois? That's west of the Mississippi. I don't know.
I could be wrong.
Does that, as a one-time judge here, can that kind of revocable trust survive here, do you think? You had some skepticism, I guess.
Well, the appellate court there said yes, and apparently it was considered a legitimate realm of choice. I think we can all conjure up situations where a restriction of one kind or another, particularly one that might otherwise disinherit a person from making a particular choice, might not be enforceable for public policy reasons or others. But in this case, the court determined that this was a legitimate exercise of discretion to promote marriage within the faith, which was something extremely important to both the original testator who had died first and his wife.
It was Nevada. It was Illinois, by the way. Thank you. So, okay, we've all mostly gone to law school. Here comes the slippery slope. The next case, hypothetical case, is saying to the son or daughter, if you do not keep a kosher home, the trust is revoked. And we will, we'll send somebody out once a month. Or, if you want to get a little more tricky, if you marry someone of a different race, the trust is revoked. Can you imagine a court upholding a will that restricts someone's trust on the basis of a racial disparity?
I'm glad you asked the question that way. The answer is yes, I can imagine that a court somewhere, sometime might. Sorry, I'm a literalist. That's a bad call.
I understand.
But there's a situation where right, as we perceive it, viscerally and intellectually and in terms of every value that we might hold, might not necessarily be served by the law. if it were I would try to find a means by which a clause prohibiting interracial marriage might be held invalid
Well-
in this day and age. But I can't say that that would be supported by precedent in the jurisdiction in which I operated.
See, what I'm trying to throw a light on here is how what looks like one kind of decision can be seen as another kind of decision. I mean, I shouldn't make an assumption. Your sense of that Illinois case that says it's perfectly okay to revoke a trust if this girl marries out, this woman marries outside the faith, you okay with that?
I think what you have to remember is the shoe can fit very differently on the other foot. What if it would say, if you marry a Jew, I revoke the trust?
Precisely.
Right? That would be just as well. No, but the question is, and I'll maybe turn to my colleagues here and say, what about a gift? Forget an inheritance. Let's say I say, I'm so happy that you married a member of the faith. Here's all my money. Would anyone have an issue with that?
Probably not.
Okay. Suppose the trust says, you get my money. Well, but the trust we have says only if you marry inside the faith do you get this money.
Right, but the same idea. The idea is, where do we draw the line here? I don't mean to be the moderator. You're doing a fine job. Don't get me wrong. But on the other hand, why are we drawing a line between a gift and an inheritance? What's the difference in whether I give it while I'm alive or I write it down not to be given the moment I die?
But although obviously you can come up with endless examples of this. You cannot marry outside the faith. You cannot marry a different race. You only marry a member of the opposite sex. You can only marry, if you're a Lutheran, a Methodist, whatever. And I guess what I'm struggling with here is this. You're right, Rabbi, that the individual preferences outside of a legal document are unchallengeable.
I think Dan had an interesting point, though, and maybe it depends on attitude and how we look at things. Let us take it one step farther into the will, and the will says to my darling daughter Louisa, if she marries within the Jewish faith, she receives $250,000. However, should she not do so, I leave that entire sum to Northwestern University. It's an Illinois case. Now, somehow or other, because that's expressed in the positive, as opposed to saying, I hereby disinherit my wife Louisa because she married outside the Jewish faith or something like that, sounds a little more palatable, doesn't it? I think that was the point you were trying to make, Dan, and I'm not sure there's an easy answer.
There are a couple of areas I want to touch on, and one of them has to do specifically with lawyers who may be facing a conflict in terms of distribution. He may be the executor. I want to make sure I get this right. The executor of an estate whose, say, charities may profit by the distribution. What are the limits? What limits an executor and what he or she can do with that? Have I got that kind of right?
Well, you got it sort of right, but if someone comes to you as a lawyer to draw their will, you cannot suggest to them your charity. That would be that's a pretty easy one. I think when people get into trouble is when they draw the will and the client who's their lifelong client says, I love you, Mr. and Miss Lawyer. I want you to be the executor, and by the way, I'm giving you Blackacre. That's when the problem obviously arises.
There have been cases that have made the press where fairly egregious examples of this have shown up, no? Where suddenly the person of great wealth discovers that this lawyer is such a good person that he or she decides to leave a lot of money to them.
We know there are a number of people out there, and I think many of us have seen it through the years, where there are people that befriend older people and become their family and end up with with their estate. And it's pretty egregious. But sometimes it's acceptable because sometimes they are the only family. They do take care of the people when no one else will, and, morally it may be justified. Other times,
Sounds a little like the producer's plot, but, sort of.
where do you think they got it?
What can a court do about that? How much can a court pierce a will where it seems like some very shady business has been going on?
Well, of course, will contests abound. You find them in courts all the time. I think one of the things that arises from time to time is you have multiple wills, multiple successive wills. All of them may or may not have been properly executed, properly witnessed, and things of that kind. And you have to sort through all of that and find out which of those wills, and sometimes it's not necessarily the latest, is the one that's going to govern. And invariably, those wills reflect shifting viewpoints on the testator. I was involved in one as a lawyer in which the faithful gardener received a sizable inheritance in will number 2, but he was not mentioned in either wills number 1 or 3. And other family members fared better or worse. The ultimate goal, of course, is to discern testamentary intent, but it has to be testamentary intent as expressed, not something, harboring in the back of the mind that somebody might have been thinking but never got around to saying. I think, frankly, most will contests, particularly those that involve problems of people being given an inheritance, disinherited, back in partially, and so forth, really are the cases that ought to be settled. I mean, there's a pot of money there. There are people with arguments, stronger or not so strong, maybe in certain cases, but going to the mat and particularly dealing with appeals, which are inevitable, is extremely problematic, and I think perhaps more unpredictable than almost any other type of litigation. So that one cries out for mediation. Unfortunately, Bob Margulies is the best mediator in the state,
But this, in
if
a
not
way,
the East Coast.
in a way,
I just upped the retainer.
thank God we have it's okay to advertise now. You brought us back really to the place from where we started in this sense. That is, if you're talking about a pile of money, pure common sense and logic cries out for a settlement. Everybody's going to get a lot. But it seems to me, and correct me if I'm wrong, that what you're also dealing with is when family conflicts and bitter, decades-old resentments come to the surface, common sense and logic may not be there.
Jeff, you're suggesting that self-interest doesn't rule? I mean, and if we look at the law, the law is as much a fiction as anything. We have a will act that says, here are the things you have to do to draw a will. And then we have this concept of what is the probable intent? So the courts have said, well, we're going to look beyond this statute, which we construe strictly, and say, oh, well, what are the other things, the other factors that might militate one way or the other?
I think I'm raising a different point, that instead of just saying, all right, look, our father, our mother is dead, we share in the bounty of it's like, I was there every Friday to cook a meal for her while she was flying off to the Caribbean.
Self-interest, I'm entitled.
Yeah, but I'm not even sure it's self-interest, because in the long run, it's going to cost more money and heartache than just a settlement. It's irrational self-interest, right?
There are recent studies that indicate that in decision-making, up to 70% of a decision is emotional, and only 30% is rational. Now, there's studies that say this. If that is true, why should it be so surprising?
I guess it's not. So we've come almost to the end of our revels. Reflect a little bit, each of you in turn, if you will, just based either on your experience or what we've talked about tonight, is the degree to which there's any sane general rule to mitigate the kinds of bitternesses and disputes that either clients or families get into.
I take my cue not only from you, Jay, but also from the subtitle of this symposium. Why can't we all get along? Well, the answer, of course, is that we can't all get along. Nobody's going to get along with everybody, or with everybody that comes into their lives. But you certainly, I think, whether you're dealing with intelligence, whether you're dealing with altruism, whether you're dealing with common sense, whether you're dealing with family values and realizing any number of things that give us more in common than our differences, you can certainly expand the breadth of the population with whom you can get along and the areas in which that's possible. In doing that, of course, we may well be able to help turn the tide, if you will, on the litigation explosion. A second thought, and something akin to that, which is overly simplistic. When we first started having these discussions, and while in Sunday school we read passages from the Old Testament from time to time, I didn't know whether the golden rule, as enunciated by Jesus Christ, do unto others as you would have them do to you, had any known equivalent or precedent in the Old Testament. And I was told, yes, its companion, if you will, or precedent is found in Leviticus. Well, I went ahead and read Leviticus, and I couldn't find it there, but that doesn't mean it isn't there. I mean, it's not an easy book, an easy story to read. But I think the point is, sometimes very basic tenets, like the golden rule, can and should come to mind in areas of either controversy or stress, and you take a step back and say, hey, wait a minute. Would I want to be treated like that? And if the answer is no, then maybe you don't treat somebody else like that.
It seems to me that a lot of controversy comes about because of unreasonable expectation. And one of the reasons that I drank the Kool-Aid about 20 years ago for mediation is there's an opportunity to readjust expectation. The problem, of course, is everybody wants to adjust somebody else's expectation and isn't willing to have theirs readjusted at all. But it all comes back to, a lot of it comes back to the inability of so many of us to deal with confrontation, to deal with adversity, to communicate clearly and directly what we want, and more important than what we want, what we need in any particular situation. And I think one of the things that good lawyers can do is to have full conversations with people. We're afraid of chasing the clients and all this kind of thing. But I have found that if you deal directly and lay the pros and cons out and can tone down the emotional side of the decision making that I'm now aware that people are making, then you are in a position to create a structure and rationale that can be helpful. People will then hopefully try and confront their problems and be able to avoid all this conflict.
I'll first comment Leviticus 19.
Thank you. I'll read it again tonight.
It's love your friend as yourself.
Yes.
Right? King James might have said it a little differently, but that's approximately it. I think the take-home message would be that there's a lot of opportunity as a judge, a mediator, and for sure as a lawyer to make the world a better place. When you find a family that is suffering, whether it's through inheritance, whether it's through the breakup of family business, any of the cases where we raise, and everyone knows so many other cases, lawyers really have the opportunity to make a difference and make the world a better place. If we can show our clients, and we can bring them a step closer towards settlement, towards moving past things, I think that's a tremendous opportunity. Shakespeare aside, I think being a lawyer isn't the worst thing in the world, and I think that's something we have to remember. I've been involved recently in a case of someone who passed away in the 90s, leaving an estate of $30-40 million and no children. And they left it basically entirely to charity. There was a certain charitable works that they felt very strongly about. There were two professionals in the area that they thought very highly of, and they left them as the trustees and they had long discussions in his final years how he wanted to leave it. The two trustees had a falling out, and over $4 million were spent on legal fees. And you have to wonder, this whole man's work and all of his good thoughts, what became of it? So if attorneys take that opportunity to sit down and say, yes, you're right, you're 100% right, but think about what your father would have wanted. Think about what this person would have wanted. Is it really worthwhile to go down this road? Is this really what you hope to accomplish? It's an ability to really fix major issues and make the world a better place.
Quick footnote. The rabbi referenced a famous line from Midsummer Night's Dream, I think it is, where two people say, first thing, let's kill all the lawyers. I may have mentioned this last year. The next time someone says that to you, remind them the context. These are two miscreants talking about how to destroy civilized society. And they say, first thing, kill all the lawyers. So that phrase means precisely the opposite of what some of your friends, and then you can, tell them that and then offer them a two-word expletive to just finish the conversation. The other point I would make, once again, I'm really quite amazed by the turnout and the attentiveness. And I would only point out that in this conversation, the only depressing note is that the lawyers most in need of this kind of conversation are the least likely to come to an event like this. Rabbi, I don't think you have subpoena power, but it might not be a bad idea to find some of the lawyers, you may have a list, and say, next time this is compulsory. Thank you, Mr. Tucker, Ms. Smith, Mr. Margulies, Rabbi, Judge.